fell out of a chair on a booster seat and had fallen back. And then finally, when she was questioned at the police station, she finally admitted that that story was not in fact true, that she had discovered the child at the bottom of the steps. Pilot training, that she had fallen off the toilet, that was another story she gave, but then the final version was that the child had fallen down the stairs and she had discovered him at the bottom of the steps. Unresponsive was seizing up in a state that indicated severe brain injury. Provides some closure. I mean, as the court rendered its judgment today, that she is convicted of murder of this 3-year-old child. And so I think that that was important to them. Trials are unpredictable and they are never a guarantee. So the question became for us, given the conflicting medical evidence in this case, whether or not we would push forward and insist upon a trial or resolve it the way we did. When I talked to the victim's parents, to the young child's parents, they were of the opinion that this was the proper way to go. There was some indications from the text, as we had said, that the child was a sense of frustration for her. She had her own child. This was a blended relationship and family. And so there was frustration for her for having to watch what she described in her own text as his child. And so we felt that would provide motive. But again, our experts would testify and that while it was inconsistent with falling down the stairs or falling off a chair, in these cases you never know the mechanism, and the mechanism is what actually happened, how the child was actually injured. We did not have that in this case. I believe, based on my discussions with them and the evidence that we had presented, that we know generally what would happen to this child. Those injuries were inflicted, whether the child was shaken, whether the child was slammed on the ground, whether the child was struck, as I said, with the soap dish dispenser that was found at the scene. But there's no question in my mind we would have proven, and we could have been able to prove that something happened to him. So the sentencing guidelines in this case will be prepared for the judge. So the agreement was that she will serve no more than 20 years in this case, and that was clearly not an easy decision, but one we felt, given the facts of this case and the potential issues for both appeal and for conviction, that was a fair resolution of the matter. So there is no parole in Virginia, so that would be 85% of 20 years. There's no doubt in my mind, no question in my mind, I'm going to argue for it. You have a 3-year-old child who has been taken at the age of 3. We are all definitely a little sadder, a little worse off than we were when we started the day.